Dear viewers, today we will be dealing with the lesson on consumer protection in e-commerce. Information and communication technology has changed almost every part of people's lives, and buying and selling goods and services is no exception. Information technology has led to the creation of technologies like electronic data interchange and electronic fund transfer. These technologies are made easier to use with the help of internet, and this has led to a new type of business transaction called electronic commerce or e-commerce. The e-commerce platforms make internet based trade possible in ways that was never been done before, enabling consumers to order goods and services from the comfort of their homes just through the click of a button, not only from sellers within the country but also from other countries. However, this has also posed new challenges regarding regulation and consumer protection. In recent years, India has experienced a boom in internet and smartphone penetration. As per the IAMAI, the smartphone base has also increased significantly and is expected to reach 1 billion by 2026. The India Brand Equity Foundation report states that after China and the US, India had the third largest online shopper base of 150 million in financial year 2021, and this is expected to be 350 million by financial year 2026. The Indian online grocery market is estimated to reach $26.93 billion in 2027 from $3.95 billion in financial year 2021. The overall e-commerce market is also expected to reach $350 billion by 2030, driven by the strong adoption of online services in the country. The rapid growth of e-commerce has changed consumer preferences to buy online by allowing anyone with a mobile phone having internet to order anything from across the globe. This lesson provides an overview of e-commerce, its international standards, and the current Indian legal framework aimed at its regulation and consumer protection. A thorough analysis of the Consumer Protection E-commerce Rules 2020 and relevant provisions of the Consumer Protection Act 2019 is provided in this lesson. Electronic commerce refers to a mechanism that enables the sale of goods and services using a computer network such as the internet. E-commerce increases productivity and widens choice through cost savings, competitiveness, and a better production process organization. E-commerce infrastructure has three main features. Firstly, matching buyers and sellers. Secondly, facilitating commercial transactions, and thirdly, providing the legal framework. According to the Organization for Economic Cooperation and Development (OECD), e-commerce transaction is the sale or purchase of goods or services conducted over computer networks by methods specifically designed for it. The UNCITRAL model law on e-commerce refers e-commerce to transactions carried out by means of electronic data interchange and other means of electronic communication which involve the use of alternatives to paper based methods of communication and storage of information. The WTO work program on electronic commerce defined electronic commerce to mean the production, distribution, marketing, sale or delivery of goods and services by electronic means. E-commerce models can be categorized based on the relationship between the transacting parties. The prominent e-commerce models are business to government, consumer to consumer, consumer to business, business to business, and business to consumer. In the B2G model, businesses sell goods or services to the government and its agencies. In the C2C model, consumers sell directly to the consumers via online platform by posting classified ads and auctions or by selling personal services or expertise online. The C2B model is also called as a reverse auction or demand collection model. It enables buyers to name their own price, often binding for a specific good or service, generating demand. The website collects demand bids and then offers the bids to the participating sellers. The B2B is the model of e-commerce whereby a company conducts its trading in other commercial activity through the internet and the customer is another business itself. The B2C e-commerce relates to transactions between the business houses or seller and the actual consumer. It includes retail sales, often referred to as e-retail, and other online purchases such as airline tickets, entertainment venue tickets, hotel rooms, ordering food, services, booking cab, etc. The websites like Amazon.com, Myntra.com, Flipkart.com, and applications like Ola, Uber, Swiggy, Zomato are some of the examples of this model. This lesson focuses on B2C e-commerce and protection of consumers in such transactions. The formation and validity of e-contracts or electronic contracts is the focal point in all electronic commercial transactions, including e-commerce. The International Chamber of Commerce (ICC) refers to electronic contracting as the automated process of entering into contracts via the party's computer, whether networked or through electronic messaging. An e-contract may be concluded by exchange of any type of electronic record like SMS, MMS, emails, etc. by means of a mobile phone, computer or similar devices. It is pertinent to note that an electronic contract is not a special kind of contract like a contract of partnership or a contract of agency or contract of sale of goods, etc. In fact, electronic contract is a contract which is formed electronically using electronic communication in fully or part. There are three broad categories of subject matter for electronic contracts. Firstly, sale of physical goods, wherein goods are ordered over the internet by making payment via the internet and delivery occurs physically to the address of the buyer. Secondly, sale of digitized products. Real goods such as software can be ordered, paid for and delivered online itself. And thirdly, supply of services like electronic banking, sale of shares, financial advice, etc. Broadly, electronic contracts may be classified into four types. Individually negotiated contracts using electronic mode, like contracts which are generally negotiated by the parties at the individual level using email, SMS, WhatsApp messages, etc. Click wrap contracts. The party, after going through the terms and conditions on the website or program, signifies assent by way of clicking on I agree button or decline the same by clicking on I disagree. This type of acceptance is usually conveyed before receiving the merchandise or the services. Shrink wrap contracts. The sale of software such as CD and DVD containing the software package is done through box or container which is wrapped in clear plastic wrap, through which the terms of the license agreement can be seen. Once the wrap is removed, it is deemed that such terms are accepted. Browse wrap or web wrap contracts. The terms and conditions of the website are kept under a hyperlink like terms or conditions located on the website, and the user of the website is bound by these terms upon using the services of the website. Majority of e-commerce transactions are concluded online through electronic data interchange (EDI), that is, by way of inter-process communication of business information in a standardized electronic form. The EDI enables the transfer of data from one computer to another in such a way that each transaction in the trading cycle can be processed with no paperwork. In this case, the data is formatted by means of standard protocol, so that it can be implemented by the receiving computer. EDI is frequently used to transmit standard purchase orders, acceptances, invoices and other records, and thus reduces paperwork and the potential for human errors. In this type of contracts, there is an exchange of information and completion of contracts between two computers and not an individual and a computer. At the global platform, most of the countries have adopted the 8 internationally recognized consumer protection principles as provided in the OECD guidelines for consumer protection in context of e-commerce, given in 1999 and revised in 2016 for ensuring consumer protection in e-commerce transactions. These principles include information provision. Consumers should be provided with clear and sufficient information to make an informed choice about whether and how to make a purchase. Contract formation. Vendors should take reasonable steps to ensure that the consumer's agreement to contract is fully informed and intentional. Privacy. Vendors and intermediaries should respect the privacy principles set out in the Personal Information Protection and Electronic Document International Model Code for protection of personal information, like accountability, identifying purposes consent, limiting collection, limiting use, disclosure and retention, accuracy, safeguards, openness, individual access and challenging compliance. Security of payment and personal information. Vendors and intermediaries should take reasonable steps to ensure that transactions in which they are involved are secure. Consumers should act prudently when undertaking transactions. Redress. Consumers should have access to fair, timely, effective and affordable means of resolving problems within any transaction. Liability. Consumers should be protected from unreasonable liability for payments in transactions. Unsolicited commercial email. Vendors should not transmit commercial email without the consent of consumers or unless a vendor has an existing relationship with a consumer. Consumer awareness. Government, business and consumer groups should promote consumer awareness about the safe use of electronic commerce. The UNCITRAL Model Law on E-commerce 1996 establishes rules for the equal treatment of electronic and paper-based information as a guide for making legislations by different countries in view of harmonizing the laws. It provides legal recognition to the transactions done through electronic means of communication, gives legal recognition to electronic signatures for the authentication facilitates electronic filing of documents, electronic storage of data, and gives equivalence to electronic records as that of physical records. Another significant development at the international level is the EU regulation on online dispute resolution for consumer disputes 2013, which provides for setting up of a uniform ODR mechanism across the European Union for the settlement of consumer disputes in online transactions, and it has become operational from 2015. E-commerce is subject to various rules and regulations owing to its cross-cutting nature. Some of the significant laws governing e-commerce are the Information Technology Act 2000, the Indian Contract Act 1872, Indian Evidence Act 1872, etc. The Information Technology Act 2000 has been enacted basing on the guidelines provided by UNCITRAL Model Law on e-commerce. Further, the evidentiary value of e-contracts can be well understood in the light of sections 85A, 85B, 88A, 90A and 85C of Indian Evidence Act 1872 that deal with the presumptions as to electronic records, whereas section 65B relates to admissibility of electronic record. Any information contained in an electronic record which is stored, recorded, copied on optical or magnetic media produced by a computer shall be deemed to be a document and is admissible as evidence in any proceeding without further proof of the original. The section 10A of the Information Technology Act specifically gives validity and recognition to contracts formed through electronic means, where in a contract formation the communication of proposals, the acceptance of proposals, the revocation of proposals and acceptances are expressed in electronic form or by means of an electronic record, such contract shall not be deemed to be unenforceable solely on the ground that such electronic form or means was used for that purpose. Therefore, an electronic contract has the same legal validity as a contract formed through conventional mode of communication. This in turn provides legal validity to all the e-commerce transactions. Consumer protection in e-commerce in India. The Consumer Protection Act 2019 contains specific provisions relating to e-commerce. The section 2 subclause 16 of Consumer Protection Act 2019 defines e-commerce as buying or selling of goods or services including digital products over digital or electronic network. The section 2 subclause 17 defines electronic service provider as a person who provides technologies or processes to enable a product seller to engage in advertising or selling of goods or services to a consumer and includes any online marketplace or online auction sites. In February 2019, a draft national e-commerce policy has been prepared and placed in the public domain, which addresses 6 broad issues of the e-commerce ecosystem. They are e-commerce marketplaces, regulatory issues, infrastructure development, data, stimulating domestic digital economy and export promotion through e-commerce. Further, section 94 of the Act empowers the central government to take necessary measures for the purposes of preventing unfair trade practices in e-commerce, direct selling and also to protect the interest and rights of consumers. Hence, the Consumer Protection e-commerce rules 2020 were notified by the government on July 23, 2020 and also a minor amendment was made to it on May 17, 2021. Consumer Protection E-Commerce Rules 2020. Applicability of rules. As per Rule 2 of the E-Commerce Rules, it shall apply to all goods and services bought or sold over digital or electronic network, including digital products. All models of e-commerce, including marketplace and inventory models of e-commerce. All e-commerce retail, including multi-channel single brand retailers and single brand retailers in single or multiple formats, and all forms of unfair trade practices across all models of e-commerce. The Rule 3b defines e-commerce entity as any person who owns, operates or manages digital or electronic facility or platform for electronic commerce, but does not include a seller offering his goods or services for sale on a marketplace e-commerce entity. The inventory based model includes an inventory of goods and services owned by an e-commerce entity and directly sold to consumers. Example, online stores of manufacturing companies. In the marketplace model, an e-commerce entity has an information infrastructure platform on a digital and electronic network that facilitates the consumer and the seller. Example, Amazon, Flipkart, Croma, etc. However, the rules shall not apply to any activity of a natural person carried out in a personal capacity, not being a part of any professional or commercial activity undertaken on a regular or systematic basis. The duties of e-commerce entities include: where an e-commerce entity is a company incorporated under the Companies Act, it must appoint a point of contact to ensure compliance with the Act, that is, a nodal officer shall be appointed. They have to establish an adequate grievance redressal mechanism. They would appoint a grievance officer for this purpose and display his name, contact details and designation on their platform. He would acknowledge the complaints received within 48 hours and resolve the complaint within a month from the receipt of the complaint. If they are offering imported goods, the importer's names and details from whom the imported goods are purchased and the seller's names are to be mentioned on the platform. They cannot impose cancellation charges on consumers unless they bear similar costs. They have to effect all payments towards accepted refund requests of the consumers within a reasonable period. They cannot manipulate the goods prices to gain unreasonable profit by imposing unjustified costs and discriminating against the same class of consumers. Now, let us understand the liabilities of marketplace e-commerce entities. The marketplace e-commerce entity would require sellers to ensure that information about goods on their platform is accurate and corresponds with the appearance, nature, quality and purpose of the goods. They would display the following information prominently to its users at appropriate place on its platform: details about the seller's offering goods, principal geographic address of its headquarters and all branches, and name and details of its website for effective dispute resolution. Separate ticket, docket or complaint number for each complaint lodged, through which the user can monitor the status of the complaint. Information about return, refund or exchange, warranty and guarantee, delivery and shipment, payment modes and dispute or grievance redress mechanism. information on the methods of payment available, the protection of such forms of payment, any fees or charges payable by users. They would make reasonable efforts to maintain a record of relevant information, allowing for the identification of all sellers who have repeatedly offered goods that were previously removed under the Copyright Act or Trademarks Act or Information Technology Act. Now, let us understand the seller's duties on the marketplace. The seller would not adopt any unfair trade practice while offering goods. He should not falsely represent himself as a consumer and post product review or misrepresent any product's essence or features. He should not refuse to take back goods purchased or to refund consideration of goods or services that were defective, deficient or spurious. He should have a prior written contract with the e-commerce entity to undertake sale. He should appoint a grievance officer for consumer grievance redressal. He should ensure that the advertisements for the marketing of goods or services are consistent with the actual characteristics, access and usage conditions of goods. He should provide the e-commerce company with its legal name, the primary geographic address of its headquarters and all its branches, the name and details of the website, email address, customer contact details such as faxes, landlines, mobile numbers, etc. Now, let us look at the duties and liabilities of inventory e-commerce entities. Since in the inventory based model, inventory of goods and services is owned and directly sold to consumers by e-commerce entity. So, inventory e-commerce entities have the same liabilities as the marketplace e-commerce entities and the same duties as the marketplace sellers. The 2020 e-commerce rules strike a balance between the responsibilities of e-commerce business owners and on the platform vendors. The rules prescribe a set of obligations that the platforms and the sellers covered by these rules need to adhere to. These obligations ensure that the interests and rights of consumers are secured. In order to ensure that the same happens, the platform holder has to appoint a nodal officer or alternate senior functionary is tasked with ensuring that the platform holder complies with the rules and the act. Further, any contravention of these rules would invite the provisions of the Consumer Protection Act 2019. Draft amendments to the Consumer Protection E-commerce Rules 2020. The Department of Consumer Affairs has proposed amendments to Consumer Protection E-commerce Rules 2020 and also sought suggestions from stakeholders in July 2021. The significant amendments that are proposed are: the definition of an e-commerce entity is expanded to include two new categories, that is, entities engaged by an e-commerce entity for the fulfillment of orders and related parties as defined under the Companies Act 2013 of an e-commerce entity. A marketplace e-commerce entity is said to have a fallback liability in case of non-delivery of goods or services by a seller. Marketplaces may not list associated enterprises as sellers and use information collected by it for the unfair advantage of such enterprises. The abuse of dominant position by e-commerce entities is prohibited. E-commerce entities must appoint certain personnel, including a compliance officer and a nodal person, for coordination with law enforcement agencies and provide information under their control or possession upon request by government agency. The e-commerce entities shall make suggestions of alternatives to ensure a fair opportunity for domestic goods. Further, the rules propose to regulate mis-selling, cross-selling and flash sale practices. However, these amendments to the rules have not yet been notified and the draft is pending. Apart from this, the Consolidated Foreign Direct Investment Policy Circular of 2020 has only permitted for FDI backed e-commerce entities to engage in B2B e-commerce and not in business to consumer e-commerce. Also, the new set of regulations entitled Indian Standard 19,000-2022 Online Consumer Reviews, Principles and Requirements for their collection, moderation and publication was launched by the Department of Consumer Affairs to fight the fake review menace on e-commerce platform in the country. These standards will be applicable to every online platform which publishes consumer reviews. The Department for Promotion of Industry and Internal Trade DPIIT has also envisioned the Open Network for Digital Commerce ONDC to democratize the digital commerce by carving a level playing field for the e-commerce giants and small sellers, that is the kiranas. In the ONDC network, sellers can voluntarily choose to display their products and services throughout the platforms and apps which have joined the same. The pilot phase was launched on 29 April 2022 in 5 cities: New Delhi, Bengaluru, Bhopal, Shillong and Coimbatore. Dear viewers, the protection of consumer rights is a paramount in the growth of e-commerce, and the new regulations strengthen the grievance redressal mechanism of online consumers, ensuring their trust building ability, safety and security. It can be said that in light of these new regulations, in the context of e-commerce in India, the consumer is not only king, but the king with power. Thank you.